Good afternoon.
Good afternoon, Your Honors. May it please the Court, my name is Nathan Maurer. I'm the counsel for the plaintiff appellant in this matter.
If you would speak up just a little bit.
Yes, sir. I'll try to do that.
Okay.
As I said, my name is Nathan Maurer. I'm the counsel for the plaintiff and appellant, Jessica Munoz, in this matter. I'd like to reserve 3 minutes for rebuttal.
Very good.
This appeal is made from the trial court's order granting summary judgment. The appeal is made on the grounds that the court erred by finding that the evidence presented in opposition to the motion for summary judgment was insufficient to create a genuine dispute of material fact. Granting of summary judgment is reviewed de novo by this court with no presumption of correctness. This is a dog bite case. The central question on summary judgment was whether the defendant, Jose Sepulveda, knew or should have known of the dog's dangerous propensities prior to the bite. The pertinent facts are as follows. The defendant was in the business of selling meat from his property in Wilson County. Plaintiff appellant Jessica Munoz went to his property on July 16, 2021 for this purpose to purchase meat. Defendant kept a dog on the property, a Great Pyrenees, that stayed with and protected the animals. Ms. Munoz alleges that as she walked towards the area where the defendant was standing after she arrived, the dog approached and bit her on the right hand through the rectangular wire fence.
So the dog was there to protect the animals?
That is what the defendant testified to. He was asked, does the dog protect the animals? He said, yes, that's its job. He actually also testified that the dog wouldn't leave the property and that he couldn't take it to the vet because it wouldn't get in the car. It just wouldn't leave the animals.
Did the dog have a name?
Suki.
Suki.
Yes, sir.
Okay.
S-U-K-K-I. The defendant denied that the dog had ever bitten anyone or showed aggression towards strangers. Specifically, he was asked if the dog ever growled at strangers, and he said no. He did admit that the dog was protective of the animals and that he put a beware of dog sign on the property because there was a church next to the property where children were often seen playing. He was asked why he needed the sign if he had a fence around the dog, and he testified because the children could have possibly climbed the fence. He also testified that when he sold the property, he abandoned the dog there because it did not know how to be with other people.
Did he explain what that meant?
I don't recall. I'd have to go back to his transcript, but I don't think he gave any other explanation other than it just didn't know how to be with anyone else. It sounded from his testimony, if you read it as a whole, that the dog was somewhat reclusive and, again, wouldn't leave the animals, wouldn't get in the car to go to the vet. In response to the defendant's motion for summary judgment, the plaintiff produced a declaration from a former customer. Her name is Maria Mendoza. She testified through this declaration that she too went to the defendant's property several months before, about 6 months before the incident where Ms. Munoz was bit, and that as she approached the fence, the dog came, this is a quote, came towards me and began growling and showing its teeth in an aggressive manner. She also testified that the defendant was there and observed this event, and she believes that he was aware that the dog had acted this way.
Did she say what the defendant did? Did he intervene? Did he pull the dog away? Did he say, oh, this dog won't bother you, don't worry about it, or anything like that?
She did not. It was just
okay.
In her declaration. The court found that the record was absent of proof that the dog had or that the owner had knowledge that the dog had a propensity or was accustomed or had an inclination to bite, and there was no proof that the dog had ever done so or attempted to do so. The court also held that the plaintiff had no evidence that her specific injury arose from the dog's propensity to bite. Plaintiff appellant believes that these findings by the court were in error and that the court failed to properly consider the evidence presented in the light most favorable to the plaintiff as required by the summary judgment standard. The plaintiff appellant submits that the dog's dangerous propensity in this case arose from its protective nature and its aggression towards strangers. The defendant admitted in his deposition that the dog was protective and that this was the dog's job to protect the animals on his property. A reasonable inference from this evidence is that the dog was protective against any animal or person that it perceived to be a threat to the animals that it protected. This is also supported by the evidence that he posted the beware of dog sign on the property out of concern for children playing in the area. There is no dispute then that the dog was protective, and there is nothing in the case law that suggests that protectiveness or wariness of strangers cannot result in a dangerous propensity.
One of your arguments is that the credibility of the defendant is at issue.
That's correct, Your Honor.
And if the credibility of a material witness is at issue, summary judgment is not appropriate, if I understand your argument.
That's correct.
Now, let me assume for this discussion that the defendant's credibility is indeed at issue. But does that relieve you as the plaintiff of the initial burden to show that the defendant knew or should have known of the propensity of the dog to attack?
Well, the appellee supported that argument at the summary judgment stage with the appellee's denial that the dog had ever shown aggression. That's the only evidence that the appellee used to negate the element of the plaintiff's claim that he knew of the dog's aggression. We believe, as I'll address in just a second, that Ms. Mendoza's declaration brought that statement that he made, or at least conflicted with that statement. The appellee points out in his brief that Tennessee law holds that a dangerous propensity can arise from viciousness or playfulness or mischievousness. It follows then that if a dog is inclined to injure a person out of a protective instinct, that protective instinct may constitute a dangerous propensity if it inclines the dog to show aggression or attack any person it perceives to be a threat. We submit that there was sufficient proof in the record before the trial court to create a genuine dispute of material fact as to whether he knew or had reason to know that the dog was inclined to injure persons who approached the property out of a protective instinct. The most direct proof, as I mentioned, is in the form of the declaration by Ms. Mendoza. The circumstances of her visit to the property and the plaintiffs were almost identical and were only about 6 months apart. Like the plaintiff, Ms. Mendoza was also visiting the defendant's property to purchase meat that he had advertised for sale. She states in her declaration that as she approached the fence, the dog came towards her and began growling and showing its teeth in an aggressive manner in the immediate vicinity of the defendant. She stated she was frightened and backed away from the fence and that her perception was the dog was not friendly with people, especially strangers. This is consistent with the defendant's acknowledgement that the dog was protective. It does directly conflict with his testimony that the dog had no history of showing aggression. Again, he testified in his deposition he had never seen the dog growl at anyone or growl at a stranger. But that is exactly what Ms. Mendoza says in her declaration, that the dog growled at her as she approached. This conflicting testimony challenges the credibility of his testimony and creates a disputed fact as to whether the dog had in fact shown aggression in his presence towards a stranger before it bit the plaintiff. If the testimony in Ms. Mendoza's declaration is to be believed, which it must be at the summary judgment stage, then this incident happened in the presence of the defendant. For the trial court to have found that there was no dispute of fact, it must have credited his testimony over Ms. Mendoza's, which we believe was an error at the summary judgment stage. It is well established that a determination of witness credibility is not appropriately resolved by summary judgment. But even without his statement, or without those two statements conflicting, we believe that the testimony by Ms. Mendoza through declaration created a dispute of fact as to whether he knew or had reason to know. Appellee contends that a singular instance of behavior by the dog as witnessed by Ms. Mendoza was insufficient to put him on notice of the dog's propensity to cause injury. He cites the case of Alex versus Armstrong, where the court found that one instance of a dog running, jumping, and chasing in a playful manner was insufficient to put the owner on notice that the dog had a dangerous propensity born out of playfulness or mischievousness. Armstrong is distinguishable in the sense that the behavior as witnessed by the plaintiff was common to most dogs and not immediately indicative of anything dangerous. But the behavior of the dog that Ms. Mendoza witnessed is quite different than running, jumping, and playing. If the dog had merely barked at Ms. Mendoza, when she approached, that would probably be expected of most dogs when a stranger approaches and wouldn't put the owner on notice of anything unusual. But according to her declaration, it growled and showed its teeth in an aggressive manner. The most notable act there, I believe, is the baring of the dog's teeth, which is clearly a warning to any person approaching an unfamiliar dog not to approach and conveys a form of aggression or protectiveness, if not viciousness, towards the person approaching. Whether that's born out of viciousness or protectiveness or protective instinct is irrelevant. If it inclines the dog to cause injury, then that constitutes a dangerous propensity. It's also notable, we believe, that the dog allegedly engaged in this behavior in the presence of its owner, which a reasonable jury can conclude is beyond the normal degree of protectiveness and wariness and is more akin to aggression and viciousness. Certainly a reasonable jury, considering this evidence in its totality, could conclude that the dog really did approach Miss Mendoza in this fashion, growling and showing its teeth, that the defendant was on notice that the dog was aggressive towards strangers and likely to cause injury. A reasonable jury could also conclude, if her testimony is believed, that he was not being truthful when he testified that he had never seen the dog show aggression towards strangers. Finally, the court held that the plaintiff failed to present proof that her injury resulted from the dog's specific dangerous propensity. We submit that this was also an error and that the proof shows instead that the dangerous propensity of the animal was aggression towards strangers approaching the property, and that the dog's inclination to show aggression and attack strangers approaching the property was exactly what caused her injury, in this case, a bite to her right hand. Excuse me. I'll reserve the rest of my argument
All
for
right,
rebuttal.
thank you, sir. Good afternoon.
Good afternoon, Your Honors. My name is Chad Massey. I'm representing Jose Sepulveda. Your Honor, it is the appellee's position that the trial court was correct, that there was no issue, genuine issue of material fact, and the summary judgment was appropriate in this matter. As you know, this case arises out of a dog bite that happened on the property of my client, Jose Sepulveda. If Your Honor, please, when you look at the dog bite statute, it's divided into two sections. One, if the bite happens off the property. One, if the bite happens on the property. That is handled in subsection C, subsection 1, and that basically carries the one bite rule that we've seen through Tennessee's history. And that's been going on for probably the last 100 years, that if you have knowledge that or should have knowledge that the dog is aggressive or vicious, then you have to take precautions to protect those.
Well, you don't. You said the one bite rule, but
Right.
It's really not a one bite rule, is
Right.
it? It's a propensity.
Right, it is propensity, and that's what we're about to get to. When you look at it, what does dangerous propensity mean? Now, the court has called that by numerous types of descriptions throughout its court's history. It's used dangerous disposition, dangerous propensity, vicious propensity, and what it's looking at is the character of the dog. Is this a dog that goes around attacking people all the time? We've always heard the idea of a junkyard dog. You see the dogs that if you walk up, it jumps on the fence. It runs up and down the fence. It bites. It's trying to snap. It's trying to go after you. Now that's what a character or a propensity. Now what is the propensity of a dog? Does a dog have a propensity to bite? And what does that propensity mean? It means an inherent inclination to go after someone and bite it. Is that dog's character? Is that what that dog
The
does?
plaintiff testified that the dog was aggressive and jumped up to the fence where she was. And then she had a witness who said the same thing happened 6 months earlier.
No, she never testified. When she arrived that day to buy a goat, she got out of her vehicle with her husband. She walked over to the fence to look at a puppy that was also in there with the other goats. And she said the dog was laying down, the dog wasn't moving, didn't bark, didn't do anything, and next thing she knows, her hand was bit. The one before, the person approached the fence, the dog growled, one isolated occasion. She walked away, the dog walked away, never attempted to bite, never made any attempt to bite. Didn't hit the fence, didn't bark, didn't run up and down, approached, growled, left. That was the entire isolated event. To have something that would be considered as far as character, it's a pattern of behavior that dog possesses and would demonstrate over time. That's how it becomes who you are. You are you are your habits, what you do over and over again.
What about the dog not knowing how to be with other people? That was your client's statement.
Right.
What does that mean?
It's a speculative argument. He says he doesn't know how to be with other people. The dog had lived it with that one family since it's been a puppy. in the field with the goats, and any efforts to rehome it, they didn't think would be appropriate. And obviously this
So he
happened
just left
post.
it?
And this, what's that?
So he just left it there?
Well, he talked to the church. The church wanted to buy their property, and the church wanted it, and he said, can we leave him here? And he testified that they agreed. I mean, they wanted the property, and they agreed to take care of the dog, and then ultimately they didn't want to take care of the dog.
Okay. What about the beware of the dog sign? You put it up because there were children that played nearby.
Right.
Doesn't that indicate he knew that there could be a problem?
A sign gives them a precaution, a protection to a homeowner who has dogs on his property. There are dogs present, and you think if you put one up, and I'd say Tennessee homeowners think that they put one up and they're protected if their dog does do anything. It's just a protective measure. Now, does it provide any information that the dog had bitten someone before, or that dog is likely to bite in the future? It doesn't. Now, if you look at the Miso versus Williams case from 1914, they had a dog that said, bad dog. If you have a sign that says bad dog, then you would expect them to know that the dog would be bad. But when you put a beware of dog sign, it doesn't necessarily mean at all that the dog has bitten anyone or is likely to bite anyone. And I would say there are numerous homeowners in the state of Tennessee that their dog has never bit, has never knocked anyone over, hasn't done anything, but they have a beware of dog sign just for their own protection.
Okay.
In order to be held liable, the dog owner must show that the dog is naturally inclined to be dangerous, and that it was that specific inclination to do harm which resulted in the specific injury. In this matter, there is no evidence that there was a dangerous propensity to bite, as the dog had never bitten anyone prior to this date, attempted to bite anyone, or had a natural inclination to bite. When you look at the evidence that they have, all they have is 3 speculative arguments, and then this affidavit, and we'll talk about each one of those. In regard to, we just talked about the beware of dog sign, and that is, like I said, a preventative measure, presumably to provide protection to homeowners, and the sign is no evidence of the dog owner's knowledge of previous bites, and it doesn't have any, doesn't show any knowledge that the homeowner knew of any dangerous propensities. In regard to him being with the animals, it says that he was protective of the herd. Now, to be protective is not equated with aggressiveness. You could say of a parent or a grandparent that they're protective of their children. It doesn't mean they're necessarily aggressive. It means they're protective. When you have to put that in context. He also said, would he be protective? You have to look at the context of that question. Would, we're looking at the modal verb. It's like in a hypothetical. So we have Mr. Sepulveda making a statement. Is there a possibility that he would be protective of the herd? He says, I think he would. And then we go through, and then we equate that with aggressiveness, and then we make our argument of, see, this is how he doesn't know how to be around. He doesn't, he's protective, so that protectiveness is going to show itself or manifest itself as aggressiveness, which is not necessarily true at all. I mean, that is just a leap of faith. It's totally conjecture to think that because he's protective of goats, that he's going to be aggressive towards humans. There's just no causal connection or no logical connection to that. And the last one is
So what does protective mean?
If a fox came in there and tried to kill a goat, I think that the dog would have done his job as a shepherd, and to protect the.
Well, so if a person comes in there and looks like they're going to, take a goat, do you think he would do the dog would do the same thing?
I wouldn't know.
Well, you don't know about the fox either, really.
No, I really don't. I'm just thinking. I figured that's what shepherd dogs are bred to do. Protect the goats, not protect the borders of the yard. As you know, Suki was 7 years old at the time. As far as Mr. Sepulveda knew, Suki had never bitten anyone. He had him since he was a puppy and had never shown any dangerous propensity that he said he saw. In regard to this affidavit, we have one affidavit from Maria Guadalupe Magana Mendoza, that stated that she came to the property, approached the fence, and that the dog growled at her. One isolated occasion, no pattern of conduct, and walked away. We're talking about a very short duration intervention. Dog walked up. So what I think is very important to note is what did the dog not do in either case, with the case currently before the court or the case with Ms. Mendoza. The dog didn't run up and down, didn't bark, didn't try to get through the fence, didn't try to get over the fence. It just let her know, I don't want you here, and they walked away. There was no attempt to bite. To say that that puts a property owner on notice that their dog is likely to bite because it growled on one occasion, it just doesn't, it's just not logically coherent. To say that that is enough, that is sufficient to show that he knows that the dog would.
If one example isn't sufficient, what about collectively looking at all the testimony about this dog, very protective of the goats, doesn't know how to deal with other people, affidavit that it growled about this lady? Isn't that enough is that enough to create a genuine question about the attitude of the dog, such that it gets the plaintiff by summary judgment?
Well, the problem is you have three speculative arguments.
Well,
and
they're speculative in the sense, I suppose, that who knows what would have happened if the woman hadn't backed away when the dog growled. But it's not speculative that the dog growled. It's not speculative that the dog's owner said he didn't know how to deal with other people. It's not speculative that he was very protective of the goats.
Right, but the thing is you don't know what, like when you look, I divide those into three different arguments. The first argument is the beware of dog sign. It's speculative because it doesn't say.
I didn't even bring that one up.
Yeah, I'm just bringing it up. It just doesn't say, there's no fact that says this is what the dog owner knew or this is what the dog has done. Then you get to the one with he doesn't know how to be away from the dogs. None of those arguments say what the dog has done, the dog is bitten, or the dog will bite. It just doesn't have any, there's no probative value in that. And then you go to the last one, he doesn't know how to be with someone else. It doesn't talk to anything about the dog being, biting anyone or that the homeowner knows. I mean, that fact, it doesn't forward that fact at all. And then when you have this last one, you have one, take it in the light most favorable to the plaintiff. On one occasion, the dog growled. Okay? Has the dog ever bitten anyone? No, there's no proof of that. Has the dog ever tried to bite anyone? There's no proof of that. All we have is the dog on one occasion growled. And these are dogs. I mean, these aren't aliens. I mean, most people have had some association with dogs. We know what dogs do. Some dogs bark. Some have an inclination to bark at people. They'll sit in their backyard and bark and drive people crazy. Some will howl. Some will run zoomies around the yard, maybe knock someone down. I mean, dogs have their unique personalities. But to say, it's their burden to show that the dog had some type of, the dog has to have some type of dangerous propensity in order for my client to know that there's dangerous propensity. And if it's just not there, and there's not evidence of it's being there, it's just insufficient. The facts of the matter are when Miss Munoz arrived at the house that day, the dog was lying down, not barking, not running, behind a fence with 2-inch by 2-inch rectangle woven squares. She walked up, and the dog bit her hand. But it was the first time that ever happened. It's the first time that we know that the dog had ever attempted to bite anyone. It's the only fact that we have. In short, Ms. Munoz's reliance on the speculative arguments and the affidavit that states the dog growled from behind the fence is insufficient to establish that the owner's knowledge of that there was a dangerous propensity. Thank you.
All right, thank you. Mr. Bauer.
Just briefly, the plaintiff's burden at summary judgment is not to prove by preponderance of evidence her case. The plaintiff's burden is to show that there is a genuine dispute of material fact in the record, and it's established that this can't be a scintilla of evidence, but there's definitely more than a scintilla of evidence here that this dog had aggressive tendencies towards strangers and that the owner knew about it. Ms. Mendoza's declaration by itself establishes, again, that the dog showed aggression in his presence towards a customer who was visiting the property for the purpose of purchasing meat. Pelley's counsel reduces this declaration to the dog growled. Again, I think it's important for the court to consider that that it says not only did the dog growl, but it bared its teeth. I think any owner, and if that declaration is taken as true, then the jury would have to conclude, that he saw it. He saw the dog approach someone who was walking towards his property, who he had invited there, growled and bared its teeth at this person. That could definitely be, for a reasonable jury, an indication that the dog was aggressive and he'd seen the dog be aggressive. I'd also like to just elaborate a little bit on his testimony regarding the dog not knowing how to be with other people. I asked him a question. You said Suki didn't know how to be with other people. What did you mean by that? He answered, well, it's just that I believe that maybe that he didn't know how to adjust to being with other people at another house. Question, is there any particular reason why you thought that? Answer, no. Question, nothing to do with his behavior? Answer, no. His answers there aren't consistent with his conclusion that the dog didn't know how to be with other people. He didn't want to explain why the dog didn't know how to be with other people. He just admitted that it didn't and then denied it had anything to do with the dog's behavior. We believe that testimony is not credible in and of itself, and that a jury could conclude that he did know. And I think that the court should have looked at this evidence in its totality. They should have looked at his statements about the dog's nature, should have looked at the fact that there was a sign, that he felt concern for nearby children, and looked at Ms. Mendoza's affidavit or declaration more carefully, and concluded that there is enough evidence here to create a dispute of material fact. Thank you.
Thank you for your arguments. We'll take this case under advisement. Call the next case, please.